Next case on the docket is MICIC versus Adventist Health Systems.
Good morning. My name is Harvey Hardy, and I am here for the appellant Anna MICIC. We're here today because we submit that the trial judge abused his discretion in failing to grant a continuance in this case, which was unopposed and there had been no continuances before in this case, which resulted in the case being dismissed. We have three reasons that we believe even individually would have been sufficient, and the failing to grant the continuance based on any of the three.
Counsel, before you get into that, when was this case filed initially?
2002, I believe, sir.
Okay, and when was the trial supposed to take place?
06.
06.
Yes, sir.
Can you explain why a lot of these things that you're complaining about now that you wanted a continuance for weren't done during that period of time?
Well, the thing that my co-counsel didn't become ill and incapacitated and unable to continue until 06. That's one.
But I mean, you've got a period of time there where you could have accomplished all of the things that you were complaining about later on, deposing doctors and all of these things. You could have done all of that, and you could have been ready for trial probably in 2 years, couldn't you?
No. And the reason we couldn't be ready in 2 years is because we had in this case initially multiple defendants, multiple lawyers. The doctors that were witnesses, most of the witnesses were doctors, and the defendant doctor was out of state, and I believe during that time she was pregnant. Anytime we tried...
Well, you got 6 years. She's only pregnant for 9 months, so I mean, there's plenty of time to take depositions and do all of the things that you needed to do to get ready for trial.
None of the things that were grounds for the moving for continuance could have been done any earlier because it didn't arise until later. And again, every time, it took at some events a 6-month spread of time to get all 5 lawyers and the witness able to take a whole day and go out of town.
Let me ask you this. Before the pretrial conference and the pretrial order in January of 06, how many depositions were taken of medical people, not lay witnesses, but either expert witnesses or treating physicians? How many were taken?
There were no expert witnesses taken.
Right.
One of the defendant doctor was taken. The medical examiner was taken twice. And there was one of the and Dr. Springer was taken. Also, during that time, there were fact witnesses taken. We had a very difficult time, for example, finding one guy who literally hid from us, and it took 6 months, and I think that the appellees finally ran him down. He was there when the accident happened. He knew one of the defenses was that my client or the decedent was somehow comparatively at fault for not calling an ambulance and for going to the hospital in his car or in a neighbor's car. They wanted to find out how bad hurt he was. Fine. But he literally hid. I mean, literally hid for months. And we proceeded along. We also tried to weed out some legal issues involving ORHS, which we finally got taken care of, and Florida East. We didn't know whether Florida East had any the hospital itself, as opposed to the ER doctors and the ER doctor, had any individual liabilities in this case when we filed it. And these days with the waiver of joint and several liability, you end up filing sometimes when you really don't think you ought to, but you do, to find out whether you're missing something on down the line. We only got a 2-year statute here, so we can't be fooling around with people. So we have, I think at one point we had 5 or 6 lawyers and it's 5 defendants, and it's very, very difficult to proceed rapidly with that many very large defense firms involved and 2 plaintiffs' counsel.
If this continuance had been granted, how much time was necessary to be ready to then go to trial? As I understand it, one of the complaints was you hadn't been able to find a lawyer to take over the case.
That's correct.
There had been several months and you hadn't been able to do it, and you still didn't have it. So if this had been continued, it would have been another year?
No, sir. The case, even before Mr. Harris withdrew, he told me that his back was just, he wasn't going to be able to do it anymore. So I gave the file to a well-respected medical malpractice lawyer. I thought he was going to take it, kept it for 90 days, and then it appeared back on my doorstep. So now I've lost 3 months thinking that I'm going to get co-counsel. I went to another fellow. He said, well, gee, Harvey, if you can get this case continued, I can probably help you out. Okay. I know that it's an unusual circumstance to have the lead counsel have to leave because of health reasons. I know, too, that trying to find somebody to take over a medical malpractice case that's close to trial is very, very difficult. I believe that the defense counsel believed that since we hadn't ever had any continuances before, and they're the ones that moved it for trial, not us, that there was going to be a continuance because they agreed to it.
Counsel, why didn't you try the case?
Your Honor, I may have practiced a long time, but I have never tried a medical malpractice case.
Well, it's got to be a first time for everything.
Well, I don't agree with the notion that I ought to jump into an area that's that complex and that's that specialized. I mean, I don't want to try a securities fraud case either.
Well, what's the significance of being co-counsel? I mean, if you're not qualified to try the case, one of your options is you give it to somebody who's qualified and you don't represent yourself as co-counsel. If you're going to be co-counsel of a case, do you have an obligation to be in a position to try the case if for whatever reason your other co-counsel can't?
I don't know that that's so, Your Honor, with all due respect. My role was to try the damages part of the case and to do the research and write the briefs, much like an associate would do. Wouldn't be, even though I've been around for a while, I do not have any medical malpractice experience beyond doing damage issues, writing briefs, doing research. That was going to be my job.
I just remember cases when I was in practice, if you were in federal court, for example, or even in state court, if you decided to appear as local counsel, supporting some big national firm who needed a local presence, the judge made it real clear that you were counsel in the case. And when all of a sudden the lawyer from New York had conflicts and couldn't try the case, they weren't terribly sympathetic about it. Their position was, you appear as counsel, that means, if need be, you try the case.
Well, in the in re the estate of Rutherford that I cited in my brief, that's pretty much exactly what happened. And there was an estate handled in, I think it was Palm Beach County. And when the estate was over, the counsel for the estate wanted to secure attorney's fees. The PR had in the meantime moved to New York. She had a New York lawyer who wasn't versed in the practice of probate practice down here. He looked and looked and looked to try to find a lawyer to take over because of the prominence of the lawyer in the local lawyer. It was difficult. He didn't find anybody. Trial judge down there made him handle the hearing, got a bad, awful result. And it was reversed because under those circumstances, they should have allowed him sufficient time. Now, you asked how long it would have taken how much of a continuance would have been taken. The second guy I talked to, it wouldn't have taken much. I mean, I'm not saying six months.
Let's talk about what's in the record, since we're limited to the record. Was there an indication made at the time of the hearing when the continuance was denied how much additional time you would need if you got a continuance?
I don't think it's in the record, sir, no. Anyway.
Let me ask you, does the record indicate why the PR couldn't be there other than that it was personal inconvenience because of work and personal matters?
No. Now, remember, there's an additional problem here.
Well, before we get to the
Right.
past, but should a judge ever accept that? You know, if a litigant says, I can't be there, I have work and I have personal reasons and nothing more?
Yes, sometimes. But let me remind the court that it's not like we went when we were told we were going to go. We were given, it was a 3-week trial period, less 1 day because of 3 or 4 weeks. Judge below was not going to try the case. He brought somebody else in. He said, okay, you're going to go during the week beginning, I believe it was September 8th. Well, as a judge, I've got my client, I got clients out of town that's not going to be convenient. I've got the parents are in Moscow trying to reconcile their marriage. He said, well, sorry, but it's not likely you're going to go. There's a case in front of you, you're not going to go. Okay, I took a chance, didn't go. Fine, they roll it over to the next trial docket, I go to the other guy, I get a lawyer, we're up and running. But then, get a call, oh yeah, by the way, now we've moved. You got 10 days, we're going to put you on another trial date with another trial, with another judge. And that's part and parcel of the problem too. It's not like we could bring them here and not bring them here and then go through the expense of bringing them twice or trying to get them here on short notice.
Does the trial order include any language to the effect of you got to be ready to go anytime during the 3 or 4 week trial period?
I don't know, candidly.
Actually,
I don't think so.
The trial judge here denied their motion for continuance when they said we have a 4-week trial in front of another judge, or counsel does. Is that correct?
I don't think they ever moved for continuance. They filed a notice of conflict.
And that was denied.
Well, I don't know, because after we didn't go during the time we were told we were going to go, then we're told there's 2 other dates. One was in October. Well, they couldn't go in October, and so essentially, yeah, they were allowed to go when it was convenient for them. I mean, exactly. Remember, this was an agreed motion. I think a lot of the problems with the discovery not getting done was because I don't think they were sandbagging. I think they thought, just like I did, the case was going to be continued because it had never been continued before. I had an ill co-counsel that had withdrawn 118 days before the trial. I had been diligent in looking for somebody until we didn't get it continued, and I couldn't find anybody else. I mean, the 3 main Myers factors. Is there injustice to the movement for denying the motion? Absolutely. Is anybody inconvenienced? No, they agreed to it. And would it be unjust for them? No. Were the circumstances unexpected? Did I expect that Gene Harris was going to get so disabled that he couldn't continue on and enroll in his case? No. Did I expect that it was going to get told that I have 3 days to get to California during the trial period? 3 days before the trial period to do experts that were supposed to have been revealed in June? Remember, they had answered interrogatories. There were 3 experts given in interrogatories, and they would not tell us which 2 they were going to use until after the trial date. After the discovery cutoff date. I'd like to reserve the last.
You got about 6 minutes left.
May it please the Court, my name is Michael DeLugo. I represent Dr. Springer in this appeal, and we would submit that the trial court acted totally within its discretion in issuing the order and judgment that he did under all of the factors that were presented to the court. As this court has pointed out, this lawsuit was filed in March of 2002 based on an incident that took place in May of 2000. So the trial date that had been selected in the pretrial order, or the trial period, was a full 4.5 years after the lawsuit was filed. The Supreme Court envisions 18 months to get a lawsuit from the filing of the complaint to the trial. This was 3 times as long as that.
Did you object to the continuance?
We did not object to the original motion for a continuance.
So does that mean that on at least the third factor under Page, which is whether the opposing party would suffer prejudice or inconvenience, you didn't assert that you would?
We did not oppose the motion for continuance, but I would certainly submit to this court that Dr. Springer is entitled to some finality in the course of a lawsuit that had been going on for 4.5 years.
If you didn't object to the continuance, you apparently weren't asserting at that point that he was entitled to some finality, right?
That is correct. And under the circumstances, I mean, the motion for continuance was filed, the first motion for continuance was filed literally days after Mr. Harris withdrew. And under those circumstances, we didn't oppose it, but the issue in the motion for continuance wasn't actually presented to Judge Cohen until August. The motion for continuance was not set for hearing until the matter was brought up 4 times during the course of August, the last time on August 22nd during the course of a pretrial. And each time Judge Cohen said no. This case was noticed in January. We sent out a pretrial order on January 23rd. You had 7.5 months to get everything ready. And so, no, I'm not going to continue this case.
When did you all identify the 2 expert witnesses you were going to use at trial?
We identified 3 experts in June of 2005.
Limited to using 2?
There was no order in the record that limited us to 2.
Was there some indication you were only going to use 2? Where does this statement come from about didn't know which 2 you were going to use? Was there some indication you were only going to use 2 of them?
As I said, we identified 3 experts in June of 2005, and then when the motion for continuance was initially denied by Judge Cohen in August of 2006, that is when counsel requested dates for the experts that we were going to call, and it was at that point that we said, okay, these are the 2 experts that we're going to use, and these are the dates on which they will be available to testify. I believe it was August 28th and August 31st were the dates that were given for their availability, and one of them was located in Los Angeles and the other was located in San Diego.
Between June of 2005 and August of 2006, was there ever a notice of taking deposition of any of your experts? Any of the 3?
There was between June of 2005 and what was the second
When you
date?
disclosed the 3.
Right.
In August of 2006, when Judge Cohen first denied their motion for continuance.
I believe that once we gave dates, then a notice was issued, and then...
But that was late August.
I'm sorry?
But that was late August with...
That's correct. That was late August.
I'm
That was the
asking
28th
between
and
June of
21st.
2005 and early August 2006, were there any attempts to depose those 3 experts?
There were discussions, I believe, but as part of those discussions, we as defense, we insisted on taking the plaintiff's experts first, and there was some difficulty in getting the plaintiff's experts set for their depositions, and so those depositions were not completed until June of 2006. And so we would not make our experts available until we had taken the depositions of the plaintiff's experts.
Did they ever seek to have, file a notice of taking deposition or seek an order with the trial court to make you produce your experts prior to, well, at any time, actually?
I don't think there was a motion to compel a file by the plaintiff or any attempt to force the issue by the plaintiff until the communication started in August of 2006. Under the factors in Cole and there are other cases that have been cited in the briefs, there are 3 main factors, and the first factor that is cited is whether or not the decision to deny the continuance would create an injustice for the movement. And I think that in the brief and perhaps a little bit here today, we're confusing the issue of prejudice as opposed to injustice. And I would agree that obviously the dismissal of a lawsuit is prejudicial to the plaintiff, clearly. But the issue is this an injustice? And I think if you look at all of the factors that went into Judge Cohen's decision, I think that you'll agree that the that Judge Cohen did not abuse his discretion in finding that there would not be an injustice under the circumstances of this case. As I indicated, the notice for trial...
Counsel, as I understand your argument, you didn't object to this motion for continuance.
Correct.
Why?
Well, because the motion, as I said, the motion for continuance was initially filed literally days after Mr. Harris withdrew because of his medical condition. And I think under those circumstances, in June, it would not have been appropriate to oppose a motion for continuance in light of Mr. Harris's condition. However, the trial court in this case felt that there was enough time for counsel, in this case Mr. Hardy here today, to either find counsel who was sufficiently experienced in trying medical malpractice cases, or for himself to learn the medicine sufficiently so that he would be able to try the case as well. But the record is clear. I'm not attempting to argue differently. We did not oppose the original motion for continuance. And the amended motion for continuance was submitted the day before the trial date. It was submitted on September 27 of 2006. The trial was scheduled for September 28, I believe. And that was, again, denied. And as part of the order of denial, the case was dismissed. But as far as the issue of injustice, again, this pretrial order came out in January of 2006, and that gave 7.5 months to plan for, number one, for Ms. MICIC to make arrangements to be physically present here in Central Florida for when the trial was scheduled. That didn't happen, and the record reflects that didn't happen because she had work-related issues that required her to be in New York during that time frame, and also personal issues that required her to be out of the country during that time frame. There was nothing stopping the plaintiff from having a co-personal representative appointed who was local. I've been involved in cases in the past where there has been a co-personal representative appointed, perhaps a local attorney who could be physically present at trial. Nothing of that sort was attempted in this case.
Was there anything specific in the motion other than the personal representative has business in New York and personal matters outside the country?
Nothing as to the personal representative. There were other issues that were raised on other topics, but as to the personal representative, that is what the motion stated, that she had business in New York. I believe she worked for the Ritz-Carlton, and she lived in California. She had business in New York, and then she had personal business outside of the country. And I think that is all that the record reflects. The other issues that were raised in that motion or in the amended motion were the fact that the Shevchenkos, the parents of the decedent, were physically located in Moscow at the time. But again, there were 7.5 months from the trial order to the trial to make those arrangements to be here during that trial period. And there were 10 days from the order actually setting the specific date of trial in which to make arrangements to be physically present. Would it have been expensive? Sure, it would have been expensive, but it was doable. And it does not take 10 days, or it is possible to fly from Moscow to Central Florida in 10 days. But again, this goes to the issue of whether this dismissal constitutes an injustice. And I think if you look at all of the facts leading to Judge Cohen's decision, I don't think that it can reasonably be concluded that he abused his discretion in making the decision that he did. As far as the experts being deposed late, again, that was an issue that the counsel did not force the issue until August. That's why the dates that were offered were in late August, concededly outside of or after the discovery cutoff, but they were prior to the trial date. And under the circumstances, it was August. It was difficult to make arrangements. The doctor has doctors had busy schedules, and it was, really it was difficult to get the dates that we did, but we were able to make them available. And I believe that if the record reflects that it was counsel's for the Ms. MICIC's decision not to take those depositions, they were available to be deposed. There are 5 sub-factors for the court to consider in addition to the 3 main factors, and I think those sub-factors also weigh in favor of Judge Cohen's decision here. The issue of the length of the continuance that was being requested, there was no indication as to when this case would be tried, if this case had been continued. The original trial order scheduled the trial for 7.5 months out, so there's no reason to believe that this would have been any different. It would have been at least 7 to 8 months before the case would have been placed back on another trial docket.
Had the parents and the personal representative been deposed in this case?
Yes.
So there were deposition testimony that could arguably have been used at trial if they were out of the country?
I say that very definitively. I've seen the depositions of the Shevchenkos. I have not seen a deposition of Ms. Micic, so I don't know whether one was taken of Ms. Micic. So I'm afraid I can't tell you that. I know that none of them were filed, so they're not part of the record, but I'm trying to recall my looking through the file, and I'm willing to bet that they were, but...
Mechanically, what happened that this trial didn't go forward? The judge denied the continuance, and then what happened?
And then the judge entered an order and final judgment dismissing the lawsuit.
Because the plaintiff said they weren't going to go forward without it?
Correct. The plaintiff was not ready to move forward. The plaintiff did not have the party, the personal representative physically present, and the plaintiff could not move forward because the two beneficiaries under the wrongful death statute, the parents, were not going to be physically present and able to testify at the trial.
But they had their deposition.
Correct.
But did the plaintiff's counsel tell the judge we're not going to go forward with the trial?
The plaintiff's counsel moved for a continuance, an amended motion for continuance. That was denied. There was no hearing scheduled in between. So the only request for the continuance is what was filed on paper in that amended motion for continuance.
Well, what I'm trying to figure out is if you deny the motion for continuance, the dismissal doesn't necessarily follow. That just means the judge expects the people to show up on that day in question, and if the plaintiff doesn't show up, then you dismiss it. So I'm trying to figure out, same question Judge Palmer had. What were the mechanics where the denial of the motion for continuance turned into an order of dismissal?
The mechanics were, it was all conflated. The order denying the motion or the amended motion for continuance was basically terminated the lawsuit.
I still don't understand how that came about. How did the dismissal get entered, balled together with denying the motion for continuance, absent some representation from the plaintiff that they're not going to go forward?
Can I have a moment to go grab the order?
Sure.
In paragraph 6 of this is entitled "The Order Denying Plaintiff's Motion to Continue Trial and Dismissing Case." This is the order of Judge Cohen dated September 28th of 2006. Paragraph 6 states, "The plaintiff not proceeding to trial as scheduled, the case is dismissed. No final judgment will be entered until expiration of the time to appeal or receipt of a mandate from the 5th District Court of Appeal." I believe what happened...
What's the date of that order?
September 28, 2006.
Which was the day, that was the day the trial was scheduled to start?
That's correct. And the amended motion for continuance was filed the day before, I believe. So on the morning of, the case did not go forward as scheduled, and so that day, Judge Cohen issued this order.
Did you oppose it renewed? That order refers to a renewed motion for continuance. Did that ever get argued before Judge Cohen, or was it just something that he summarily denied?
It did not. He summarily denied it. I believe the timing of it was that it was the amended motion to continue was filed literally the day before.
Yeah.
So we didn't have an opportunity. There was no opportunity to do anything. I think that we were prepared to argue in opposition.
Your position is that when this order got signed on September 28th, the date the trial had arrived, and they weren't there?
That's correct.
How do you distinguish the Rutherford case where you have two counsel and the one is unavailable right before trial and the trial judge tells the second one, will you handle it?
The Rutherford case has a number of distinctive characteristics that are different from this case. Number one, the amount of time at issue in Rutherford was weeks rather than months, as was the case here. Number two, the record in Rutherford reflected that the attorney from New York had called, I believe it was 15 different lawyers in the Palm Beach County area to attempt to get someone to handle the case. And every single one of them said, I'm not doing it, because, and what the opinion says is that they did not want to go up against the attorney on the other side, because the attorney on the other side was so well respected within the community. And so it appeared that there was due diligence in seeking to get counsel, but it was just literally impossible to get an attorney under those circumstances. I understand the difficulty that Mr. Hardy had here, but it certainly doesn't rise to the level of what the attorney was faced with in Rutherford. And again, what's also significant was that the issue was a question of, I think, only 6 weeks from the filing of the motion for fees and the scheduled hearing on the fee issue in Rutherford. So I think all the timing factors and there are some unique circumstances in Rutherford that are not applicable here. And unless the court has any further questions, I'll rely on the contents of the brief. Thank you.
Thank you. If I may clarify, you asked what were the mechanics. Judge Cohen wasn't going to try this case. He had brought in either a senior judge or a judge off of one that didn't have a docket. I decided the day before, when I knew I couldn't go forward, that I would not aggravate things, if you will, by showing up at trial and going, I can't go forward. I went in to see Judge Cohen the day before and said, don't get the jury, don't get the new judge to come down. We're not going to be able to go. That's why he was the one that did the dismissal. I suspected the visiting judge, if you will, would have had to sign off on it.
Why couldn't you go forward at that point? Call your clients and say the trial's starting tomorrow morning, we're going to pick a jury, we can put our experts on first, we can use up a few days, but you better get on a plane, and if you're here within 3 days, we can put you on the stand. And PR, you better get here from New York, because the trial's starting tomorrow morning, and we'll drag it out as long as we can, but eventually we're going to have to put you on, and by the way, if you can't make it, we'll use your deposition.
I didn't have the medical discovery from the appellees.
Because you didn't go out and take the deposition on August 28th and August 30th when they were offered, right?
With 3 days' notice to get out there and take them 1 day apart. And notified 4 days beforehand that we're supposed to prepay one expert, and we got the facts. Well,
you can certainly try a case without having deposed the expert if the alternative is that the case is going to be dismissed, right? Presumably, taking it even if you have to go cold against the experts is preferable to a dismissal, isn't it?
Well, I think sometimes, and I'm not trying to be flip, hindsight is a lot more clear than foresight. At the time, I didn't have them. I didn't have the discovery I needed. I didn't think that once we didn't get reached during the trial period, that we were going to, get called and told, hey, come on down.
Well, we're beyond that date now. We're now beyond that date. You now know you're not going to get your continuance. Your option is to go in and try the case as best you can with what you've got, or let it be dismissed and now the statute of limitations is run so you're out of court forever. Why don't you go in and at least try it as best you can with what you got then, as opposed to just letting it be dismissed and having no shot?
Because then you get a verdict and a judgment, and you don't have error in the record of trial.
In Rutherford, that's exactly what happened. They had the hearing. The attorney, who had very little time to prepare, got a very bad result. And on appeal, I don't know if it was the only issue, but raised the issue of a denial of the continuance and prevailed. But, in that case, they went forward. If they had gotten a good result, I'm sure they wouldn't have appealed.
I honestly didn't think about calling my clients in Moscow who don't speak English and trying to get them here within a couple of days, because I didn't have enough witnesses to put on for a couple of days. The only deposition transcripts we had of them were from a translator, And it didn't occur to me to try and,
You had their deposition though, correct?
yes, sir.
And you had expert witnesses of your own to put on?
Yes, sir, they were deposed as well,
No, but you had them available live if need be, right?
if need be, yes, sir.
Okay.
That's correct. Their experts, I wanted to clarify, they were going to tell us which two they were going to use after they finished our expert deposition, which they did in June. Had they told us in June who they were going to use, we could
When they gave you a list of 3,
Yes, sir.
did they indicate at that point they were only going to use 2, or could they have used all 3 if they
They told
wanted?
us they were only going to use 2 because we had only used 2.
Back in June of '05 when they gave you 3.
Yes, sir. Now, I want to say,
I mean, theoretically, you could have deposed 3 of them, and then you would have been covered, right? You had a year to do that if you wanted.
I'm willing to bet you that they weren't ready to be deposed, that they were just listed. I'm willing to bet you they weren't ready to be deposed by the end of June of '06, because we couldn't
Well,
get
there'd be
dates.
one way to find out, wouldn't there? There'd be schedule them and take their depositions, and then you'd know, right?
Yes, sir, you are correct. You are correct with that. I wanted to also point out another case that I didn't mention when I was up here before. It's the Florida Fruit and Vegetable Association case, which involved a 68-year-old lawyer that wanted to withdraw and did it because he was sick, and they wouldn't let him. And the denial of the motion to continue was overturned and deemed an abuse of discretion. When I was preparing, it was difficult to decide whether all 3 of these things came together, and just yesterday I thought, all of this problem came out of Mr. Harris's not being able to try the case, not being incapacitated. Deciding to ask somebody to take over, them keeping the case for 90 days or so, not getting a continuance granted that was unopposed, and it was never opposed that I recall.
Was one of the reasons for not taking their expert depositions that you weren't the lawyer who was going to deal with the medical issues and you still hadn't found a replacement?
Yes, sir, that's one of them. I mean, I did attend our own experts' depositions, but I didn't take them, and I was not comfortable taking theirs, especially with 2 days' notice.
Thank you, Counsel.
Thank you.